Hi, my name is Rita Amorichinda and welcome to IP Series COVID-19 edition where I talk about recent IP cases and development globally from copyright, trademark, patent, industrial design, geographical indication, plant varieties, and trade secrets. If this is your first time in listening to my podcast, please subscribe or follow me so you don't miss out on any episode on Anchor. You can also follow any of the other distribution platforms like Spotify, Breaker, Overcast, Radio Public, Apple Podcasts, Google Podcasts. And for listeners who have always been listening to my podcast, thank you guys so much for always tuning in. You can always send in your questions to ipseriesInfo@gmail.com or pardoo PARDOO PRIME legal@gmail.com. So let's get right into today's topic. So, on today's IPS episode, we will be talking about trademark and domain names to be generic or not. And our case study for today is the United States Patent and Trademark Office (USPTO) against Booking.com. This case is like the most anticipated trademark case of the year. And one of the things that actually made it stand out was that the oral arguments were heard via phone calls, and that's the first time in 231 years that the Supreme Court has ever done that. So it was like record breaking, and the lawyers were all females, and the lead judge, and one of the lead judges died recently. That's Justice Ginsburg. May her soul rest in peace. So let's get right into today's topic. Per tradition, we always have a case study for each topic, and our case study for today is the USPTO et al. Against Booking.com. So sometime in 2011 and 2012, Booking.com, a travel reservation website, wanted to register a wordmark and a styles version of his website as a trademark, but its application was rejected by the USPTO, that is the United States Patent and Trademark Office, for being generic in nature. And Booking.com appealed to the U.S. District of Virginia, and the court agreed with their arguments that even though Booking.com was generic, it described the type of service that the company offered, which is a reservation website, a travel reservation website, and that they had acquired secondary meaning over time, and therefore they were eligible for protection as a trademark. But the USPTO disagreed with that and appealed to the Fourth Circuit, arguing that by adding a generic word, that it doesn't make it non-generic. So non-generic is like a term that has become common amongst everyone. But the court did not agree with their arguments and upheld the decision of the district court by relying on evidence that consumers already recognized Booking.com as a brand and not a generic service. And in summary, they also held that if a mark comprising of a top-level domain name is added to a generic term, its source is significant to the relevant public, the mark is not automatically ineligible for trademark protection. The USPTO wasn't happy with that and went ahead to appeal and urged the Supreme Court to, do a judicial review of the decisions held so far, and they requested a certiorari. So a certiorari basically is a special proceeding by which a superior court requires an inferior tribunal or board or judicial officer to transmit the records of his proceedings for review, for excess of jurisdiction, and stated that the .com doesn't have any significance of its own, like a generic corporate indicator. um, they also that the USPTO also relied or made reference to a 19th century Supreme Court case that held that adding a generic corporate identifier could not create a trademark that enjoys protection. And like I've always stated, trademark or IP, in order for you to enjoy your IP, you need to register it in order for you to get legal backing and give you exclusive rights to your intellectual property. So finally, on the 30th of June 2020, during that lockdown period, the first ever conference call oral argument in the history of the United States Supreme Court, and that is in the 231 years. Um, this is the first time it's happening. The court held that booking.com was not a generic name to the consumer. And the late Justice Ruth Bader Ginsburg, may her soul rest in peace, delivered the opinion of the court as follows: that it stated that we reject, I'm reading verbatim, we reject the PTO sweeping rule that the combination of a generic word and .com is generic. A term style generic.com is a generic name for a class of goods and services only if the term has meaning to consumers. So, in my next post, I'm going to talk about what trademark is, and I've talked about that before. We're going to look at the grounds which the court looked at and came into conclusion at the end of the day, how that's applicable in Nigeria. What is a trademark? So a trademark is a type of intellectual property, otherwise known as IP, and regarded as an intangible asset, which could be in form of a word, sign, slogan, symbol, smell, anything used in relation to business or used to differentiate or distinguish one business or brand from the other. We have types of marks like the service marks, the certification marks, the community marks. However, today we're just talking about trademark generally. Trademark is a type of IP that is used to protect brands, brand names, symbols, words, signs, etc. And in Nigeria, this is governed by the Trademark Act, while in the United States, this is governed by the Lanham Act. Now, as a trade or a registered trademark owner, you get to enjoy exclusive right to use your mark, to license it, to sell it, to exploit it, or commercialize it any way you deem fit. But in order to do all of that, first thing first, you need to register your trademark, which is what booking.com did. So they're in the right direction. They applied for a trademark for the wordmark and the styles name of the website, basically. So they wanted to register the wordmark and the styles version of its website. So yeah, um, under the Lanham Act, a generic name is not eligible for the federal trademark registration. That means you cannot register it. However, a term styled generic.com, you get, so the word could be generic, but then you include the .com to it, then it is now a generic name for a class or goods or services, and then the term must have meaning to the consumers. What do the consumers think of whenever they hear your brand or see your brand? Like the booking.com, what's the first thing that comes to your mind when you see it? A travel website um, for reservations. It also gives them statutory protection of the trademark. Now, um, what is a domain name? I'll answer that in my next post. What is a domain name? So I'm sure a lot of us that are listening have a website that is a domain name. So a domain name basically is a source identifier that assists consumers based on the jurisdiction in identifying a website through its unique internet address. So if you own a trademark, you need to go ahead to register the domain name. I mean, they go hand in hand. You can't do without the other. Whereby you don't do that, and you have cases of cyber squatters who go ahead to register it and probably hold it to ransom or whatever. I know we had an issue like that last year where the Air Nigeria domain name was registered and the cyber squatter was demanding for millions of naira. But I mean, you get it. So um, while doing your trademark registration, also do your domain name registration. And then again, I need to say something. In Nigeria, um, if you go ahead to do your CSC registration without doing your trademark registration, you're just doing yourself. You're causing disservice to yourself and your brand and your company, because where there's a conflict as to who has the upper hand, trademark has the upper hand. But that's aside. So I'm going to talk about the similarities between a trademark and a domain name. So the similarities include they are both source identifiers, they are um, both intangible assets. However, for the domain name as a source identifier, this is through the website. Um, for a website through its internet protocol, while for trademark it's the name, the logo, the sign, anything that distinguishes a brand from another. Then registration prevents third parties from using it without their permission, and we know that in IP, consent or permission or authorization is key, and then it's also territorial in nature. What are the differences between the trademark and the domain name? So trademark registration is done at the trademark registry. Domain name registration is being regulated by the Nigerian Internet Registration Association (NIRA), which is in charge of Nigeria's country code top level domain name, while globally the Internet Corporation for Assigned Names and Numbers (ICANN) is in charge for regulating domain name registration. Now, trademark registration can be registered in any of the 45 classes. Trademark disputes, the Federal High Court has exclusive jurisdiction to hear any trademark or IP related dispute. However, where parties don't want to go to court, they can opt to settle via alternative dispute resolution mechanisms such as mediation, arbitration, conciliation. While for domain name dispute, this is resolved via the Uniform Domain Name Dispute Resolution Policy, that's the UDRP, which is prepared or was prepared by the World Intellectual Property Organization for resolving internet domain name dispute. So if someone registers your domain name, I think the fastest route for you would be to opt for the WIPO ADR mechanism, resolve your dispute. Then for trademark takes the form of a sign, word, logo, symbol, letter, smell, whatever. While for domain name, it's a combination of letters and numbers to have a second level name and top level domain name, e.g. Facebook, Konga is a second level name, while the .com or .ng is a top level domain name, which is classified as a generic top level name, top level domain name, and country code top level domain. And finally, for trademark, the functions is that there must be goodwill, the brand must have goodwill and reputation, especially when there's an infringement and you need to sue. So yeah, the next topic will be on the scope of protection. So on scope of protection, we know that generally, if you wish to register your trademark, especially under the Nigerian Trademark Act, specifically from Section 9 to 11, your mark must be distinctive in nature, arbitrary, fanciful, an invented word, must be suggestive. While under the Lanham Act, trademark owners with federal claims for relief establishes a system of federal trademark registration. The owner of the mark um, registers and enjoy valuable benefits, which includes a presumption that the mark is valid. So in the US, um, in order for you to register your mark, there's a presumption that your mark is valid to be registered with the PTO. And then the distinctiveness criteria is often expressed in an increasing scale, where word marks may be generic, descriptive, suggestive, arbitrary, or fanciful. And I like to, I think I'll say that both the Nigerian Trademark Act and the Lanham Act has a bit of similarities, especially with regards to criteria and requirements and infringement issues. Um, so in this case, Two Pesos Inc. against Taco Cabana Inc. And the 1992 case, it was said that the more distinctive the mark, the more it qualifies for the trademark owner to register it. And Booking.com, as we know, is a digital travel company that provides reservations and other services under the brand Booking.com, which is also a domain name of the website. So you see, as a potential or a trademark owner, you need to have a trademark and also a domain name hand in hand. You can't do without each other. And the first to file principle applies when it comes to these issues. So yeah, then I'm going to read something that the Supreme Court said when they gave or ruled that customers will understand the term booking.com primarily to refer to an online reservation service for travel tours and lodgings. And I think that's basically true, because if you go to the website, and I think customers, and that's the thing, is the perception that the customers have had over the years of knowing booking.com that really matters at the end of the day. How do these consumers see your brand when they see it on the shelf or on TV during the adverts or any other place? Then the time of duration is for 7 years, and this is subject to renewal for another 7 years. So if you own a trademark, know that you have to consistently use that trademark for 7 years for commercial purpose, else you lose the right to own that trademark at the end of the day. And that won't be, I don't think anyone is going to actually love it, but yeah, that basically covers the scope of the term of protection when it comes to trademark. So I think in the last 2 or 3 episodes, I talked about grounds for refusal, grounds for revocation, grounds for cancellation, why your marks may not be registered or approved. Now, if you listen to the summary when I was talking about the case, I said that the United States Patent and Trademark Office had initially refused to register the mark because it was generic in nature, and this is one of the grounds or reason why a trademark office may refuse to register your mark. Another reason could be that the mark is descriptive in nature. So, for instance, you want to register your bottling company, like say bottling company or bottling Jones. You already described what you want to register, or ice cream or dairy. So yeah, all of those things, anything that describes or tells someone what your product is about, is descriptive in nature. Another reason could be that your mark was opposed during registration, as I earlier talked about in the prepare against Apple Inc. case, where Apple Inc. opposed the prepare registration because, according to them, the pear logo looks like the Apple logo. It's just a fruit, but basically, I think they've been on a rampage on stopping people from using the fruit logos for any of their brand. Another reason could be that the mark is deceptive or scandalous. Um, so make sure that you check all of this so that you don't have issues with your trademark registration. So are other .com marks at risk? I think going by the decision of this court, this will depend only on whether the consumers perceive that the term as the name of a class is capable of distinguishing itself amongst other classes. So if the consumers can distinguish the booking.com mark from another um, .com mark, I think there's no cause for alarm there. So I don't think any .com mark is at risk at the moment, unless maybe the court decides to, do otherwise. So today's podcast is not going to be really long because I'm wrapping up right now. So yeah, I'm just gonna give my so what are the lessons learned? So even if your your mark is refused for whatever reasons, just like booking.com did, and you can always appeal through your IP lawyer. They can appeal to the board or the court, and the decision, whatever decision the registrar might decide to change his or her mind and grant you your request, or they might ask you to, draw up a disclaimer and change your trademark or whatever. Make sure that the mark that you want to register meets the distinctiveness test. Always consult your IP attorneys or law firm for your IP registration. Even if you attempt to do the registration by saying, make sure that you have an IP lawyer that is guiding you or is actually doing it. But I think I'll say it's better you give an IP attorney the brief to register your trademark so you don't go get into trouble at the end of the day. And so we've come to the end of today's IP series episode. Don't forget to subscribe, like, and share. Tell me what you think about this case. Do you think the Supreme Court did a good job in affirming or the circuit's court's decision that the booking.com is not generic in nature? Do you think booking.com is generic in nature? Do you think after these judgments given that the PTO should grant their request, or they should just find a way to, come up with a new name or whatever? But then again, I remain your favorite IP lawyer. Send in your questions to ipseriesInfo@gmail.com, and thank you guys for joining. See you next time. Okay, bye.